Thank you. All right, let's get started. All right, folks, hi. Welcome to today's GRadulting Workshop. The plan today is to talk about employment contracts. And hopefully our attorney will help you negotiate and enter into a contract fully understanding what they're asking, what they're laying out for you. But before we get to that, let me introduce myself. My name is Debbie, and I am the coordinator of services and programs for Graduate Student Legal Aid. I use she, her pronouns. And today's workshop is co-hosted by our office, Graduate Student Legal Aid. It's also co-hosted by Undergraduate Student Legal Aid and the Career Services Office at the A. James Clark School of Engineering. So thank you to all of our co-hosts. In addition to these weekly workshops, Graduate Legal Aid provides free virtual legal services to UMD grad students. And what does that mean? Really four things. We provide legal consultations with our attorney, whose name is Zach. We provide legal immigration consultations for our international and DACA students. We provide advocacy consultations for students who were charged with a violation of the Code of Conduct or the Code of Academic Integrity. And we also provide notary services. Notary services are the only thing that we're doing in person right now, and those happen on Thursdays. So if you'd like more information about who we are and what we do, I think Cody's going to post our website link in the chat, so take a look. So here's the plan for our workshop today. We will share the PowerPoint presentation and the recording after the workshop. If you have a question during the workshop, post it in the chat. Near the end of the workshop, we will post a link to our 6-second survey. Really, it takes 6 seconds. So please take the time to give us some feedback. That really guides what workshops we repeat. And we always get new ideas from students as well. So please fill out that survey. All right, let's move on to the topic at hand. It is my pleasure to introduce our speaker, Joyce Smithey. Ms. Smithey is a highly respected employment and labor law attorney who represents employers and employees throughout Maryland and the District of Columbia. And with more than 18 years of employment law experience, she brings a wealth of knowledge to helping her clients protect their interests. So we are fortunate to have such a highly qualified speaker and someone who is a regular volunteer for the GRadulting Workshop Series. Joyce, welcome, and thank you for helping our students prepare for hopefully some very lucrative job contracts that they'll soon be receiving.
Wonderful.
Take it away.
Thanks so much, Debbie. Thank you, everybody, for attending today. As Debbie mentioned, my name is Joyce Smithey. I've been practicing for 22 years. I do only labor and employment law. I am managing partner of a firm of 7 lawyers, all of whom do labor and employment law. So it's an area that I have knowledge and passion about. And excited to teach all of you a bit about employment contracts. It's especially valuable because I get the people who never talked to an attorney and come in with a mess. And I really wish they had sat through a seminar once and didn't make mistakes that they make before they come to me. So it's exciting that all of you are taking the time to educate yourselves so that hopefully you don't end up in a bigger mess down the road. If we can go to the first slide. Okay, so we'll start with the basics. What is an employment contract? Many people don't realize contracts don't have to be in writing. An oral agreement can be a contract. Writing, of course, is preferred because then nobody is disputing the terms. So a document that is signed by both employer and employee is really the best because there won't be a dispute as to who said what. But even an oral agreement is enough to establish a contract and something that you can sue on or your employer can sue upon. We also have implied contracts, which is, for example, I had a case where somebody said, oh, turn down that other job and I promise, we'll take care of you for the next 5 years here. And we had a case on that where someone had relied on that statement, stayed on in their current capacity. And then when they were fired before the 5 years were out, they argued that they had a contract. Employee handbooks. The law in most jurisdictions in the US, and certainly the law in Maryland and DC, is handbooks can form a contractual obligation to you unless they expressly in the beginning say this is not a contract. So when you get those employee handbooks, in the beginning, a lot of times you'll see something that says nothing in here is meant to be a contract or construed as a contract. If they have that disclaimer, then you don't have contractual rights there. But if they don't, you can even get a contractual right from a handbook. Next slide. Covenant of good faith and fair dealing. Every contract has this covenant bound into it. So even though your contract may not say, hey, everybody has to engage in good faith dealing with each other and be fair with each other, it's actually read into the contract. And you can have a claim related to the breach of the covenant of good faith and fair dealing, which means that when you're going out there, your employers have this obligation to you too. Everyone is supposed to behave in good faith in how they execute the terms of a contract. So remember that, if you get somebody, if you're in an employment situation and you feel like that, there's misrepresentations going on, people aren't being honest, that if you have a contract, every contract has a covenant assumed and implied into it that the parties will deal with each other in good faith. Next slide. So you don't have to have a contract to have a job. In fact, the great majority of employees don't have one. So if you don't have a contract, don't think, oh, there's something wrong here. One screen back. The next one? Nope. Okay, 2 forward. One more. There you go. The majority of employees don't have a contract and they're considered at-will employees. But sometimes employers will want to lock down certain types of employees. And I know we've got a lot of, for example, engineering students who are going to have access to confidential policies, procedures, technology. A lot of times they'll want a contract with those employees. One reason they might want a contract with you is they want to control your ability to leave. Without a contract, you're an at-will employee, and that means you can quit when you like and they can fire you when they like. But if they want to have the ability to keep you there for a period of time as they're investing in you, then a contract's a good idea where they say you can't leave for a year. So that's one reason they'll do it. And then they may want to require notice from you. If you leave, we want 30 days of notice so we can train a replacement. Again, if you don't have a contract, you don't have those obligations. So sometimes employers will want to do this so that they have that kind of control and knowledge that they'll get notice from you. So employers may have those interests, but it limits them as well. The things that are going to make it more likely that they want to contract with you is if you have access to confidential and sensitive information. Again, trade secrets, if you're working on government contracts in the bidding process, all of that stuff. If you have access to client information, customer information, procedures that may be, technological secrets of theirs, they're going to want to protect that. Everything that you get while you're sort of, on their payroll, they're essentially going to say, you can't use this information. We're going to talk about non-competes today. We see more and more of them every year. And the idea is that you're signing not only to say, I won't compete against you while I'm an employee, but many of them are now saying, and you won't compete against us for a period of time afterwards. And there's a lot of rules as to how those get held up. We'll talk about it, but non-competes are a big motivator on the employer side to give you contracts. On the positive side for you, sometimes it gives you job security, right? If they give you a 5-year contract that is terminated for only limited reasons, then you have job security for the next 5 years, and it might make you take a job that you wouldn't otherwise take because you want that security. A lot of contracts will spell out how they can terminate you. You want to read those. I can tell you when I have litigation, it's almost always about the termination clause. I get contracts that say, we can terminate if, the employee commits a felony. And then I have some that say, we can terminate if in our sole discretion, employee isn't performing in any way that we dislike for any reason at all, right? And so that's very different. And one, really hard to get out of unless there's a felony conviction. And the other, they can easily walk away from it. So termination clauses and how to terminate are a really important part of these. You want to look at those closely because that's going to tell you what your rights are. Should they act in a way to, separate you from your position. Typically, we see contracts coming in for the higher level employees. Again, it's unusual to see people who don't have access to confidential information, a receptionist, for example, who's answering the phones and isn't seeing confidential trade secrets. You're not going to see those employees being offered contracts. It's really given to the senior people in an organization. And again, tends to be tied to your access to confidential and sensitive information. Next slide. So I talked about this a little bit. Do they have to offer you a contract? And the answer is no. And so a lot of times people say, I want a contract, I'm upset. And I get calls from people saying, can I sue them to make me, to make them give me a contract that spells out what my job duties are? Not only are they not required to give you a contract, they're not required by law to give you a job description. They're not required by law to even give you a handbook. All of those are good ideas. But again, there's no law that says they have to give you these things. And in fact, most of the higher courts in the US say, we're not going to play the role of a many human resources that oversees how companies manage themselves. So they actually aren't required to give you anything in writing. When you say, I want my job offer in writing, they don't have to give it to you. Again, they want to attract good candidates, so most of them will. But they don't have to give you anything in writing at all. So keep that in mind, as you things that seem like they should be rights that simply aren't. Next slide. So what is in an employment contract? Now, again, we've talked about that some of these can be just verbal agreements that are very loose as far as the terms, but in a typical written contract, I wanted to break down, some of what you're going to see in there and things to look for. The first thing you usually see, it's usually in the first couple of paragraphs, are your duties and responsibilities. This is where they're going to spell out what your job entails. They're usually going to have a catch-all that says, anything else that we think, we want you to work on. But it's really going to describe, the what's in it for them. Here's what you're going to do for us. They'll also have a best efforts clause. When you see that, it's you simply agreeing to use your best effort in your work there. I always think that's such a silly clause because who's going to say, well, no, I'm not going to use my best efforts and we need to take that clause out. I've never seen it negotiated, but I see it in almost every contract I see. You know, and it is you essentially saying, hey, you know, this is going to be my best effort. You know, I'm going to, you know, put my best foot forward. The next one on this slide is really important. And this one does come up a lot, is get the copies of all documents referenced within your contract. And let me give you some examples. A lot of times they'll say that you have to abide by an employee handbook, or you have to abide by, you know, company principles and morals and guidelines. And if you're agreeing to all of that, how can you make sure you're complying if you don't have copies of it? So you want to get copies of all of that. A lot of times they'll just reference benefits and say, you know, benefits according to our plan documents. Well, you don't really know what those are and what you're getting until you have those plan documents. Another thing I see is that they'll promise bonus plans, and they'll say something in a contract that you're eligible for a bonus at the end of the year, or a merits bonus, and that it's subject to a bonus plan description. If there's ever a dispute, the plan documents will take precedence over your contract. So if there's a stock option plan or a bonus plan, you want to get those plan documents, because that's really what's going to cover you. Because if they conflict with each other, the contract falls and the plan documents stand. So when you see references, and it's very common, you're going to see all kinds of references to policies, benefit descriptions, stock plan documents, you know, all kinds of stuff like that. Make sure you get copies of it, because one, you need to know what you have to abide by, but also two, when you really want those is usually at a time where you're under some stress. And you may not be in a position where you want to be asking for these things. You may be recently terminated and trying to figure out, wait a minute, they terminated me 1 week before my end of year bonus. I need to know what I'm eligible to get. And now you can't get your hand on that document, and you'll be so thankful you got it at the beginning, because now you can really, you know, figure out, can I still get the bonus I was supposed to get next week? So get all of those documents. It's very important. Next slide. So more elements of a contract. These are the what's in it for you section. There will be a whole paragraph usually on compensation. It will include how often you are paid. Keep in mind, in many jurisdictions, we have wage laws that dictate how often employees must be paid. And so you may have rights that are even better than what's being offered in your contract. For example, in Maryland, you have to be paid at least twice a month, right? They're not allowed to pay employees in Maryland monthly. Yeah, so you want to, you know, if you don't like what you're seeing in a contract, again, look in your jurisdiction. Many states require, you know, bi-weekly payments, you know, that can back you up and saying, hey, this contract isn't going to pay me often enough. So you're going to look at that, see how often you're paid. Again, bonuses are usually promised in here. For bonuses, yep. For bonuses, you want to take a really careful look at what's being promised there, because I get so many calls from people who you know, believe they were eligible for a bonus and didn't get it. And if the words are, this is completely discretionary, it's discretionary based on performance of the company, on your performance, just discretionary and subjective according to your supervisor, you want to know that. What is the bonus plan? What entitles me to it? Do I have to be an active employee on the day it's awarded? You know, what metrics are being used? And again, the more wishy-washy it is, and the more you see discretionary, you really don't have a legal right to anything if they're withholding the discretion. So you want to read that very carefully and understand. I meet a lot of people who stick around for lucrative bonuses, and then it turns out the way it was written, you know, gives the employer a lot of latitude to get out of paying it. So, you know, make sure you read that clause, read any referenced bonus policies with it, and understand the metrics for it. And the more specific, the better for you, because then you can enforce your rights there. Sometimes you will see profit sharing, and this can take many different ways. You can see stock options, you can see profit sharing going into your 401k. Again, those are all going to be subject to separate plan documents that are governed by federal law called ERISA. And so you want to get those documents that'll say, when are you eligible to participate? What can you do? What disclosures are you entitled to, so that you really know what you're supposed to be getting. If there's stock options, those can get very complicated. Depending if you have a company that may be going public, with some of its work, they can be very lucrative, and you want to make sure you understand what your rights are. Upon a separation, for example, if you quit, do you keep the stock options? All of that stuff should be in there. And so you want to know exactly what your rights are, because they can become very valuable. You'll see a policy on expense reimbursement, very standard. I don't see a lot of disputes here. They'll have a policy. You just want to read the policy, and follow the policy. For those of you who get offered a company car, you might see that in there. That's going to be more sales positions that I see that for, but you may see that, and be sure you know what you're negotiating for. If they give you a company car but aren't paying the insurance on it, you may not want that Mercedes-Benz that you have to pay the insurance on. Moving expenses, I see this more and more. Where they'll agree to pay your moving expenses to relocate up to a certain amount, keeping receipts. Again, just follow the policies. I don't see a lot of disputes on this, although be aware of the clawback portions of these, where they say, we'll pay your moving, but if you leave us within the next year, you have to pay it back. That will be upheld. So if you take a $5,000 or $10,000 moving expense reimbursement, and there's a clawback, that's going to be one of the things you have to consider when you leave employment, to make sure you can afford to pay that back, because that will be upheld. Next slide. Benefits. Again, you want to see what those are. A lot of times you'll see a very general reference, the same benefits that we're offering everybody else. It's all going to be governed by plan documents. You want to take a look at them: your health insurance, your vacation and sick leave. I've listed all of these, retirement accounts, life insurance, disability leave. Ask for these documents so you know what you're getting, as part of this. That's a second bullet point: get the plan documents. Almost every policy book is going to reserve the right to change your benefits unilaterally. So keep that in mind. As you see that, they may change your healthcare provider all of a sudden at renewal period, and all of a sudden it's a completely different plan and your doctor isn't in it. They have the right to do it, as long as they've reserved that right in the handbook. So keep that in mind. Payout of vacation time on termination is actually regulated by law. And if your policy book doesn't expressly say we don't pay it out when you leave, they must by law pay out your accrued but unused vacation. So a lot of this stuff comes in when you're thinking of leaving an employer, and you've got to think of it ahead of time so that when you do want to leave, your exit can be as smooth as possible. If that policy's there, that they don't pay it, you're not going to get it. And if it's not there, they must pay it to you. So, one more thing to consider, upon any separation with a future employer. Next slide. Okay, duration term. This is how long are you going to be contracted to stay their employee. I've seen ones that just say, indefinitely until one or the other party gives 30 days notice. That's actually pretty common. I see that one a lot, where it just goes on and on until someone gives a notice. I see some that are very short. We're going to do a 3-month contract as a chance to sort of see how you fit in culture-wise. After that, you'll join us, on a different contract. And it can be years. Not many limit themselves to like a 5-year contract where they can't make any decisions to part ways for 5 years, but I've seen them. 1-year contracts I think are the most common. And renewal clauses. You want to pay attention to your renewal clause. Say you have a 1-year contract, and it has an automatic renewal period that's going to kick in unless you provide notice. I meet a lot of people who say, hey, Joyce, I've got a contract, but I just got my dream job offer and I want to leave. Can you tell me if I can leave? And I look and I say, you just auto renewed for a year. You can't leave for a year. So be careful. I always tell people mark dates, even though things are going so well now, you never know what's going to happen. And if you see, hey, for me to get a window where I can leave without liability is in a year and I get these 30 days, just mark it on your calendar so that you are at least asking yourself, do I need to, evaluate whether I should leave now? I could get out of this contract and renegotiate the contract at this point. That auto renew, people sign these things and they forget about it, and it keeps auto renewing year after year, and they don't even know, what their obligations are. So watch the renewal clauses. They're almost always automatic renewal that people have to opt out of. Next slide. So this one again, just so that you're not alarmed when you see it. Most of your contracts are going to say that you do not have authority to contract for the employer. They just want to make it clear that you can't go out and bind them to an agreement with somebody. Hey, I said we buy this particular piece of equipment, and then it, turns out you didn't have authority to do it. They're making it clear that you're not allowed to bind them into agreements. It's all it means. Next slide. Exclusive employment. You don't see these in all contracts. There are a lot of like medical field contracts that allow you to moonlight, do charity work. So you don't always see it. But about half the time you're going to see an exclusive employment clause that says you cannot work for anyone else in the same business during the period of employment. I've even seen some, it's not as common, to that extend to being a shareholder in a competitor business, where they won't even let you own an interest with another company. Just take a look at that. They almost always, and if you're concerned because you have a 401k that has a blend of investments, there's almost always a carve out for owning less than 5% of a company. So don't panic if you see that and think, I have no idea what's in my investment portfolio in my 401k. They almost always will carve it out to be less than 5%. Next slide. So at-will agreements, so most jurisdictions, about 90% of them in the United States are at-will jurisdictions. And what this means is the employee can quit anytime they want, the employer can fire anytime they want, and they can do it for any reason that's not illegal. And for example, could somebody come in and say, you're wearing a red shirt, I hate the color red, you're fired? And the answer is yes. As crazy as that is, it's a stupid reason to fire someone. It's not illegal. There's no protection of people who wear red shirts. And so that's an example of an at-will employment decision where it doesn't make sense, but it's not illegal because the employer can terminate for any reason that doesn't violate the law. So generally, if there's not some discrimination based on a protected class or something related to a medical leave or whistleblowing, employers can simply get out of their at-will employment relationship. So keep that in mind. There's not really a cause for wrongful termination whether it's fair or not. We really only have protections for whistleblowing, discrimination, retaliation for medical leaves, things like that. You're going to see the at-will employment doctrine echoed, if you are an at-will employee, echoed everywhere they can because it's so favorable for the employer. They're going to write it right in the offer letter. You are an at-will employee. Nothing in this letter alters your at-will employment status with us, because again, that gives them the right to fire you whenever they want. Again, as long as they're not violating any statute. They will usually have you sign an at-will agreement acknowledgement when you get the handbook, because again, they want to reinforce it, because then later, if there's a dispute over a termination, they're going to use all of these as exhibits to say, nope, you knew this was at will. We could terminate for any reason at any time. So that's what it means. It's very powerful for the employers. Contracts can alter it, but if you don't have a contract, this is going to be the status of your employment. And again, very powerful. It's the thing that allows you to be able to walk out, but it also lets them get out without notice. Next slide. So another section will be how do they get out of it, right? We're entering into a contract. Maybe it's for 3 months, maybe it's for 5 years. How do we get out of it? And there will usually be two different provisions. One for cause, right? That's where the employer is saying, you as an employee haven't done what you're supposed to do, and we have good cause to get out of this contract. The other is without cause, right? Like a layoff. We're not doing well, COVID hit, we're having to lay off a number of employees. You did nothing wrong, but we're going to have to let you go. So those are the two different ways, for cause or without cause. And you'll usually see the contract set out what happens separately for each of those. So there'll be notice provisions. So for example, for a termination for cause, there might be notice. If we believe an employee isn't performing, we have to provide notice and an opportunity to cure, right? So you may see a 30-day notice provision saying we have to give you notice for 30 days that we think you're not performing, and that we have for cause to terminate. Again, I always try to negotiate on the employee side as much notice as possible. As little wiggle room as possible for the employer. You want those notice provisions. That's what protects you from an employer coming to you and saying, employer coming to you and just saying, hey, pack your bags today. Even if they tell you to pack your bags today and you had a notice provision, then you're going to be contractually entitled to be paid for that notice period. Watch those, the longer notice periods are usually in your favor, and having some is in your favor as well. A lot of them will define for cause. Again, this is, as I mentioned earlier, where all of our disputes tend to be. And they really can run the gamut where, okay, we can get out of this if you commit a felony. All right, you're good as long as you don't commit a felony. That's the only way they can get out. And then you see the really wishy-washy ones that say anything in our sole discretion that we deem not in the interests of the organization. And if they act under that, it's really hard to prove otherwise since it's in their sole discretion. So you want to take a look at that. Obviously, the tighter they are, the better for you. Something that they really have to point to something. A breach of your confidentiality obligations. That's very specific. Now you can have a real conversation. Again, the more specific, the more protection you have that they can't take action against you, to get out of the contract. I note here, ask for an opportunity to cure. Again, that's where if they're going to try to get out of it, get the notice provision, and an opportunity to cure means, okay, you're going to give me notice for 30 days. And during that period, I'm going to prove that I can improve my performance during that time. I just had an interesting one for a very high level executive in the C-suite who was accused of sexual harassment, and they put him on a notice with an opportunity to cure, and he denied having done it. But at the same time, his opportunity to cure was 30 days without engaging in sexual harassment. It was a big right for him, right? To have that instead of just, them being able to shove him out the door for that. So that opportunity to cure gives you that period of time for whatever they're saying you did wrong to show them that you can fix that. As dark and bleak as it is, there are usually disability or death clauses. They retain their right to get out of these. They'll define disabled. Sometimes, inability to work for 3 months is a very common one. So, they have the ability to get out of this if they need to because of an employee's disability. Death clauses, again, terminate the contract usually. So it's a dark thought, but you'll see it in there in most of them that lets them get out of these contracts should any of those instances occur. Discontinuance of business. This is part of the contract that you just probably your eyes gloss over and think this doesn't apply to me, but especially if you're in technology companies that change hands sometimes, you want to know what happens. because some of them will just say, this is an assignable contract and we can assign it to whoever we want. And so we sell, and all of a sudden you're working for a company you didn't want to work for, and you're bound to them for another 3 years. And, you know, your non-compete got assigned to them. So just keep it in mind when you see, you know, discontinuance of business, that, you know, should that occur, you can be giving up a lot of rights. You know, if all your contract, you're basically saying, you can just give all your contractual rights with me. You know, the fact that I have to be your employee for 3 more years, the fact that I have a non-compete with you, you can give them to any company you want, and I'm agreeing to it. And you don't get the chance to vet the company. They may not do what you want to do. It may not be good for your career, and you're bound. You know, so you know, in high level contracts, that's actually something that's pretty heavily negotiated, particularly in certain technology sectors where we know there are going to be transactions, and assigning those contracts are likely to happen. There'll be a return of property clause. Again, very standard. I don't think we usually fight over these, but if you have laptops, cell phones, anything of your employer, you'll have to return that at the end. This will include electronic information. So if you have a bunch of their documents, you know, internal documents on your computer, you're going to have to return all of that. You're not allowed to keep that on your computer. You're probably going to have a contractual obligation to say and confirm, yep, you know, it's not just the keys to the door anymore, but any electronic data stored on my laptop, my cell phone, has been erased or returned. You know, I don't hold any company property, whether it's intellectual property or actual laptops or phones. So keep that in mind as well, that property extends to non-tangible property, including emails and stuff that you're going to have to make sure you clean up off of laptops and return at the end. Next slide. Severance provisions. These can be important. A lot of times you'll see these tied to for cause and without cause, right? So for cause, if we think you did something wrong, you don't get any severance. But if we're going to lay you off without any wrongdoing on your part, we're going to agree to 6 months severance, or 1 week for every year you were here. That's what those provisions will say. Take a close look at those. You know, that's what gives you your right for severance pay. And if they're not in the contract, the overwhelming majority of jurisdictions in the United States are not mandatory severance jurisdictions, meaning you have no right to severance unless you got it within your employment contract. Next slide. This one, all of you are going to see, given what you do. The trade secret protection confidentiality agreements. These are very common. You know, I see them all the time. And it's essentially you agreeing that anything they consider confidential, you will not share with third parties. You'll return upon any parting of the ways. You know, it's going to follow and model the Trade Secrets Agreement, the Trade Secrets Act, which most states in the United States also have codified. So very common, usually not negotiable, you know, usually very, very much based on statutory language, you know, and frankly, I think the least controversial thing they'll have you sign, because you're bound by other laws to keep their trade secrets confidential anyway. And this just enforces that. So you're going to see these again, unless you see something strange in them. This is usually the least controversial clause we look at, because most of my clients have confidentiality obligations anyway. Next slide. Evaluations. You don't always see this in there, but sometimes they'll promise evaluations on a certain time period. You know, if you want them, you can ask for them. There's no law that requires evaluations. So if it's something you want a right to, then you need to negotiate that into your contract. I think, you know, the majority don't have this. At the same time, it can be nice if they have a contractual obligation to give you feedback, because if there's a dispute down the road and they never gave it to you, you know, you've got a good argument, you know, back at them if there's going to be a dispute as to whether, you know, you're entitled to severance because it was a termination for cause or not. So you may see that in the contract. Next slide. Ownership of work product. Again, for some of you, the engineering students here particularly, they're likely going to have you assign all ownership of work products, inventions, anything that's done, a work for hire that they're paying on their dime, they're going to own, they're going to have ownership of that work product. So if you're doing it at work, it doesn't matter that it was your brilliant $1 million idea. If you did it at work, they own it. You're also probably going to be asked to sign agreements to cooperate in getting patents. So not only are you agreeing they own it, but you're agreeing that you're going to help them get the documents filed and go through the process to make it clear to everyone else that they own it. So this is usually not a negotiable part of it. Usually employers are pretty strict about what they put here, but just be aware. I've had employees who were successful at sort of getting an agreement separate, right? I had somebody working on a particular software application, and we said, everything done there will be the owners, will be owned by the employer, except this particular software program that's being worked on the side, and you can exempt it out, because if you don't, anything you do or inventions or ideas you have are going to be owned by the company during that time. Next slide. There'll be a dispute resolution process. Again, if there's a fight at the time of termination or about a failure to pay a bonus or stock options. Arbitration clauses are very popular. Employers like them a lot. They favor employers. If you think about it, arbitrators are people like me. We're attorneys. We get paid hourly for what we do. And if you're an arbitrator and you're constantly ruling in favor of employees, you're not going to get a lot of work. Because your company is going to hire a lot of arbitrators. If you hire one in your lifetime, that will be more than the average. And so most arbitrators tend to skew in favor of the employer. So again, it's hard to negotiate out of these, but be aware it's a big right you're giving away. There will be no jury trial if you were sexually harassed at work or discriminated against. Or you were a whistleblower. It can be very important. Arbitration can be binding. Again, it means you don't get to go appeal it to a court anywhere. You're just, whatever this arbitrator decides is the end of the dispute. And they can have procedures in there for how you select an arbitrator. It gets pretty dense sometimes. Next slide. Choice of law, who's going to govern the dispute. For example, non-compete is state law. There's no federal law on non-competes. So if you have a non-compete and they say, well, you're governed by Maryland law, even if you're working in California, you've agreed to be governed by whatever Maryland law is on non-competes. I use California, which is a terrible example because they're one of the states that have a law against any non-compete. They're just not allowed in California, but you can opt into another state's law that is less desirable than the one you're working in. So pay attention to that. There are some, again, California has more employee protections than any state in the United States. And if you're working in California, that's very good for you. And you don't necessarily want to opt into, I'll use a state that I know has very few rights for their employees, Georgia. Has almost no state rights for their employees or anything like that, and very favorable non-compete law for employers. So just pay attention to it. Again, a lot of times these aren't negotiable, but you will be agreeing to a totally different set of laws than the ones in the state that you're working in sometimes. Next slide. They'll talk about what happens in a breach. Again, these are going to tend to focus on what happens for them. They're not going to spell out what happens for you if they breach. But they'll talk about an injunction, saying you agree that if you violate the non-compete, we're entitled to an injunction. Next slide. Notice provisions is how they provide notice to you. We used to see by fax, for example, or hand delivery. Now we see email sometimes. Just know that if you are quitting and giving notice, you need to follow that provision to make sure that it's consistent with the contract, or it's like it didn't happen. So if they say you're fired, but they didn't give you it in writing and signed as the contract requires, you're not fired, and they have to pay you until you get it as the contract requires. Next slide. Most companies, when you join them, are going to ask that you represent you're not bound to any other non-competes. Again, they don't want to be in litigation either for having interfered with somebody's non-compete. So you're probably going to have to give a warranty. Always disclose your non-competes to a potential employer. Most of the candidates they're dealing with have them anyway. They're dealing with these all the time. It's pretty rare that I see somebody lose a job because of their non-compete obligations, but it is more likely that they lose a job if they weren't disclosed to the new employer. And then all of a sudden there's a lawsuit and the new employer gets wrapped into it and they're not very happy about it. So you'll probably have to represent there aren't any. And if there are, you'll want to disclose those. Next slide. The entire agreement clause. The entire agreement just says this is the entire agreement and nothing else. There are no other agreements. This is important because a lot of people come to me and say, hey, Joyce, but they promised me on the side that I was going to get this extra bonus. It's just not in the contract. That promise is null and void if there's an entire agreement clause that says this is it. So any outside agreements are going to fall away, and this will be the entire agreement between you and your employer. So make sure all of your agreements have made it into the contract, because the side agreements made in an email, if you've got this clause, you're not going to have a contractual right to those. So be careful with that. Next slide. This one's quick and easy. They are going to tell you to get independent legal advice. Again, they're just trying to get away from arguments of duress, things like that. So don't think, ooh, why do they think I need to go get a lawyer? You know, it's good for them to have told you that so that you can't come back and say, oh, I was pressured into signing this. And they say, oh no, it says right in the agreement, go get a lawyer. Next slide. Severability, again, this is the part where most people don't read. They call it the legalese. This just means if one part of the contract gets thrown out, say the non-compete is invalid, the rest will still hold, right? So just because they do an invalid non-compete doesn't mean you're free from the confidentiality provisions, things like that. So it just means, you know, each obligation you have is not tied to the other. Next slide. Amendments and modifications is simply how do you change a contract? And you want to follow whatever your contract says, because again, if you do it casually in an email and your boss promises you, hey, we're going to give you, a raise next year, and you do all this work because you're excited about that raise, but you didn't follow the amendment and modification clause that requires it to be in writing and signed, which is what most of them do, then you have no ability to go back and say, whoa, there's a breach here. You're not doing what you promised, because you guys didn't follow the specific procedures to amend your contract. So pay attention to that. If there is going to be a change in your employment, to make sure you're following the way the contract sets out that it must happen. Next slide. Non-compete agreements. I know this is a big topic for you guys. The law in most jurisdictions, not all, some don't even allow them, like California, just not allowed to have non-competes. But most jurisdictions will do a balancing test, and they say, we'll allow a non-compete as long as it's not overly broad. And so you'll see covenants not to compete with the business of the former employer. You'll see non-solicitation clauses saying you can't solicit our clients. Again, those get held up more often. They're very specific to the relationships you had while you were on the employer's dime. So those get held up quite often. You see non-solicitation for vendors sometimes, non-solicitation for employees. If you go, you can't bring other employees with you. So look at all of that, right? Because you may need guidance. I have a client right now who solicited positions on his Facebook page, and 80% of his Facebook were his colleagues from his former employer, and they've started legal action after him, saying he was soliciting, even though it was a broader audience than just those people, because such a chunk of them were former employees. They've started legal action against him. So be aware of the non-solicitation clauses and those non-competes. Next slide. So the reason why courts scrutinize these, they do very much believe that employees have a right to earn a livelihood. So when you get a covenant that says, this person can't work anymore in the entire state of Maryland, likely that's going to get thrown out, because people do have a right to earn a livelihood, have a job. Also, our economy is based on competition. I see this a lot with doctors. For example, you don't want to take people out of the market that, that can harm the consumer, right? If your doctor all of a sudden is gone because of a non-compete, that's going to harm the patient. And so they don't really want to stifle competition out there either, because it's good for the consumers. Next slide. So these are the things they're going to look at on this slide to decide whether or not this will be enforced. The big one that we always look at, the reasonable in scope and duration, time and geography. Most states top out at 2 to 3 years, meaning a 5-year non-compete, not going to be upheld. Geography, not uncommon to see, 15-year radius or 15-mile radius from where you performed work to be upheld. If they try to say any place we do business in the United States and they do business in all 50 states, that's not going to be upheld. So it needs to be reasonable in both geography and time. It has to be related to a protectable interest, right? So say, and I'll just use, say one company is selling apples and they have a non-compete from you selling apples, and you go to a company that only sells oranges. That's not a protectable interest because you're not really competing with them. They can only protect their interest in the business that they're in. So keep that in mind as well, right? Because if you only worked in one very specific aspect of development at a company, and you're going to do something totally different at the next company, they don't have a protectable interest in you and your work in anything other than what they actually did with you and what they do in the market. They don't courts will not uphold anything that's harmful to the public. Again, that's where we see a lot of doctors, non-competes get litigated. Again, the public can be harmed if you take a whole bunch of talented people off the market and don't let them work. It also can't be unreasonably burdensome to the employee, right? So it can't be, I have to commute 2 hours to have a job under this non-compete. The court's going to strike that down. Next slide. So protectable interest, these are the kinds of things that courts will say, yes, we'll protect that. Trade secrets, confidential customer information. It's almost always about that. 99% of my cases on non-competes are about customer lists, frankly, and customer information, their ordering patterns, pricing, software. Certainly if you're working on proprietary software, they're going to put you under a non-compete. Goodwill of the business. If they've been using your likeness in their marketing, they're going to claim that they're allowed to protect that goodwill. If you have unique or extraordinary services, this doesn't come up very often, but if you're a one-of-a-kind scientist, again, that's going to be a reason a court says we're going to give the employer some protection for investing in you. Next slide. This one, the non-solicitation of employees. And it comes from the idea of confidential information, that you confidentially know who their employers are and what their skills are and what they know how to do. And you know that from having worked there. Now that would be you soliciting them. That's you calling your buddies and saying, hey, we've got great positions here. I get a recruiting bonus if I bring you on board. Why don't you come on board? If someone just applies to the company you're at on their own, that's not solicitation, right? As long as you stay out of it. If somebody's coming in, and they reach out to you and say, hey, I'm interviewing with your company, you just want to say, I'm subject to a non-solicitation. I have no role in that, good luck, and stay out of it. Because if they come on their own, it's not a violation. It's only if you solicit and bring them on board. Copyright, tortious interference concerns. Tortious interference is what the new business will face. If you get sued for violating a non-compete, you almost always get sued with your new employer, they will claim tortiously interfered with the relationship, the contractual relationship that was there. And that's where they're going to go after the new employer, saying you're trying to steal our copyright information, you're trying to interfere with our contractual rights. And that's how they drag in the sort of deeper pockets of a company, your new employer. Next slide. And we've covered this, the reasonableness, geography, time, scope. There isn't any black letter law on this, so you just have to read all of the case law. But again, 2 to 3 years is generally the max. Anything lower than that is usually upheld for timing, geography, 10, 15 mile radius from anywhere you performed work, probably upheld. Entire states, not upheld. And so you want to balance all of that at looking at what you're signing on to. Next slide. And these, I know we're coming up toward the end of our hour, and I want to leave time for questions, but I gave you some examples of actual cases so you can see what's been held up. Insurance agent, 2 years was held okay. Another 2-year agreement. Next slide. Here's a whole list of unreasonable ones. 45-mile radius for 5 years. Yes, I would confidently tell someone in my office they're not going to be able to uphold that. Just a whole list for you to look at and give you some examples, and you can keep this. So when you're looking at it and compare, what they're having here, you see again, the 5 years. One of these is a 2-year restriction was held invalid. Gives you some ideas of what isn't being held up by courts and what they're striking down. Next slide. Again, these are the things the court will take into account. If it's people you worked with and you know who they are, they're going to protect that. If it's anybody that is a prospective customer, courts are going to say that's not specific enough. If you quit and start your own company, courts are going to be a little stricter with you than if you were fired for no good cause. Again, presence of trade secrets. The more highly skilled you are, the more the court's likely to uphold it. The more that the employer has invested in you in marketing materials, the more likely it's going to be upheld with a larger restrictive covenant. Next slide. So again, some examples. In the interest of time, I'll let you just have those to read. And my understanding is this is going to be made available to you afterwards. The next slide after that, consideration. Most jurisdictions consider continued employment enough consideration. In other words, the employer is giving up enough in exchange for the non-compete by just saying your continued employment is consideration enough. For a contract to occur, both parties have to give value. And that continued employment, most of the courts are saying is enough. Certainly in Maryland, that's the case, as well as DC. Duress defense isn't working. I note that, where I had to sign or I'd lose my job, especially I hear that a lot from people whose immigration status is tied to their job. And so they had no choice but to sign it. The courts aren't buying those arguments. As long as continued employment was offered, they're upholding these for the consideration angle. Next slide. Blue penciling just is that some courts, and Maryland is one of these, the judge can go in and edit the agreement to make it reasonable. So you could have a 45-mile radius and the judge will say, nope, I'm going to change it to 15. So just be aware a judge can come in and change an unreasonable covenant to make it reasonable. Next slide. So if you breach, you want to read what the contract says, but it's usually paying back relocation costs, prorated bonuses. But again, depending on what is in your contract, that's really going to be the dominating factor in what you have to pay if you are to breach. Next slide. Keep a signed copy. I can't emphasize this enough. If you end up in a dispute, the lawyer is going to want a copy of this. And I can't tell you how many people come to me and say, I think I signed an arbitration agreement. I don't remember. I don't have it. I might have signed a non-compete. I just met with a client last week who was having me look at a severance agreement. And I said, well, now's the time to negotiate you out of your non-competes if you want. And he said, I don't think I have any. I said, just ask. And he found out he had a 3-year non-compete that he didn't even remember signing. So keep signed copies. When things go wrong, you're going to be happy to have them. And I think next to last slide. Lawyers are out there and it can be very smart to kind of, you can be penny wise, pound foolish and not have a lawyer review your contract and then end up in a dispute where you have very little rights. And it can always be smart to get that legal advice in advance so that, should things go wrong, you're already ahead of the game with the document that's going to be litigated. And that really wraps this up. I'm happy to take questions. If anybody has some, I know the chat function is working. Okay, let's look through some of these. Should I inform employer A that I will also be working for employer B as a side hustle? Okay, so it depends on their policies, right? So first of all, do you have a contract or not? If you have a contract, look at your contract. If it has no provision on that, then it's really up to you whether you want to disclose or not. If you think there's a potential conflict of interest or a competitive issue, you may want to disclose it. But first read your contract. If you don't have a contract, read your employee handbook on what it says on having, moonlighting policies, essentially, where you can have a second job. Again, if there's no obligation in your contract or in your handbook, then you have no obligation to disclose. But if you do think it could be of something of concern, you may still want to do it, but your obligations would come from the handbook or the contract. The offers for remote work in Maryland, headquartered office in California, how will your income be taxed? You should be taxed on where you are performing the work. That starts to get outside of the scope of what I do on tax questions, but typically in Maryland, if you reside in one state, you still pay the taxes where you reside, and then it's by state law whether or not the state law will take a piece of that as well for you performing work. It's a big issue in places like New Jersey, New York. Commuter areas have a lot of complicated tax laws on that, so you'll want to get a tax lawyer to give you an opinion and advice on that. What is the difference between a benefit proposal and a contract? So a benefit proposal would be where they say, we're providing these benefits to you, and if you agree, it could become a contract. A contract is where both parties have a meeting of the minds and they've agreed to terms, and both parties have said yes, yes. If it's a benefit proposal and they're just saying, hey, we might provide these benefits to you, it's not yet a contract, so you don't have rights unless you accept it and say, yes, I agree. And those terms have been made clear that you've accepted that proposal and now have a contractual right to whatever was proposed now that it's a contract. Any other questions? Okay, well, thank you, everybody. It's so strange doing this virtually. Oh, one more. Two more. If there's an opt-out clause for arbitration, what should be considered? As an employee, arbitration is usually always bad for you. You want to keep your right to get in front of a jury trial if you can. So if there's an opt-out, grab it. It's not common. Most of the employers like their arbitration. They don't negotiate on it, no matter how fancy the lawyer is on the other side. But if you can get out of it, that's my recommendation. It's very favorable to employers. Can you get out of a benefit proposal? Again, it sounds very specific, but if it's what I'm thinking, you're talking about the benefit proposal, you just simply, they propose benefits and you just don't agree to them. But it sounds like you may have some very specific document there that's not a usual sort of, here's the benefits we're getting ready to renew on, which is what we usually consider for a benefit proposal. I do understand that the slides and a recording are going to be available. I'll let Debbie speak to that when we're done. If I have things I am still working on, which I initially patented through the university, what should I keep in mind regarding conflict of interest? Yeah, so you want to, again, look at your contract and look at the employee handbook, both of them, right? And if your contract says anything you work on during your time here, you might accidentally end up, giving them ownership of something. Now, if it's already gone through the patent process, you should be fine. But what we typically do for those clients is we'll do an exhibit that say, these are the intellectual property that, no ownership will attach. It's already previously there. So get that exhibit together, list the things that aren't going to transfer ownership and be very clear about it. That's a very common exhibit to have to an employment agreement, and check the policies, check your contract on what happens if you have a patent, but then you work and say you do a modification to it. What happens then? Make sure you've really carved things out to protect that intellectual property you've already developed. Okay, the caveats for flexible PTO. So this is really big out there, and it's not so much a legal question, although a lot of jurisdictions, there's a big trend, Maryland and DC included, to have paid sick leave now. So that's where the law really comes in and says you have to have paid sick leave for companies of a certain size, and unpaid sick leave for even larger companies, 50 or more employees. You have to have up to 12 weeks of unpaid sick leave under the FMLA. So those are really the only laws that affect flexible PTO. But, just to be cautious in the caveats for all of that, always good to remember the sick leave. For those who have the flexible PTO, some people use it all and then they don't have any for sick leave, and that can cause problems. But from a legal standpoint, they're required to give you certain amounts of sick leave depending on the jurisdiction, and unpaid sick leave depending on their size. I think I've caught all the questions.
Yeah, yes, you have.
Okay. All right. Then I will step back and let Debbie wrap this up.
All right. Wow. So comprehensive, Joyce. You always do a great job.
Oh, thank you.
And I hope this is helpful for our students. So let us know, do that 6-second survey and tell us if this was helpful to you. So with time being our most precious commodity, I want to thank you, Joyce, for sharing time with us today. I'd like to thank everybody who joined us live today, and thank everyone who is going to watch this on YouTube. Thank you to Cody in the background who helped us with any technical issues, and to Veronica as well. So next week's workshop, I hope you saw it in the chat, was what do I need to know about my credit score? So you got to know, because it does have something to do with getting a job. So everyone have a great week, and look forward to seeing you soon. Bye-bye.
Thanks, everybody.